My Lords, you should have copies of the unredacted Commission decision now, which has been handed up. If I could ask you to sort of hold off your temptation for 5 minutes, 10 minutes, I'll finish my submissions on abuse and then come back and show you the bits. There are bits that give you interest. So I will show you those and tell you what I say about them. I just want to finish abuse for now. What I was going to come back now is show the court is what the tribunal said in relation to abuse and its analysis here. So that is in the judgment. It starts at paragraph 152. Fairly whistle-stop, just sort of summary through it. Which it starts off by recording that Volvo had considered application of abuse to a follow-on action. It set out the basis there. It set out the fact that Volvo had applied there. You see that in paragraph 154 with the test manifestly unfair or administration of justice into disrepute. 155, it repeats the entirely exceptional and rare standard we also saw from Volvo. 156, it then sets out, it's referred to as the well-known section of Lord Bingham's judgment in Johnson and Gorwood, which I've shown you, that particular bit as well, but without making the point that I'm focusing on, which is the limitation of that principle. It says threshold, then 157, no dispute about its general principles. There is about the application. Threshold is a high one, but at the same time, the doctrine is flexible, not mechanistic. Referred to a decision of Tinkler versus Ferguson, at 157. That's another decided point, different parties case, as we see from 4 lines up from the bottom. I mean, these I checked, but it's a rare case where the relitigation of an issue, which tells you it is a decided point case. Different parties repeats a similar standard of their rare case there. 158, 159 explains what the position was in Volvo. Rightly clues in 159, Volvo was clearly different. It was. That was a situation in which it had been decided, and of course it had been conceded as a part of a settlement decision. 160 to 165 is the analysis of the facts of this case. I don't need to show you the detail, I show you the conclusion, which is then 165, which is here no consideration by the Commission of what level of MIF or modified rule might qualify for exemption took place, because MasterCard disavowed it. And then 166, this is not a case.
Sorry, you say 160, 165 is analysis of facts. 162 is, I mean, do you disagree with what's said in 162?
I'm saying it's the analysis of the specific facts of our case. So at the moment I'm showing you the legal approach that they took rather than the analysis that goes to their question about abuse.
Okay, you're going to come back to 162, are you?
Oh yes, I'm going to come back to what I say. I mean, the thrust of my argument primarily here is they took the wrong legal text. So I agree. That's obviously a critical part of the reasoning, but it's about what MasterCard could and should have done, which only goes to the legal test when we get there. So 166, which is then sort of the critical bit. This is not a case where MasterCard is seeking to raise again matters expressly addressed in the decision, seeking to raise an issue which could have been raised, but it very deliberately chose not to raise at the time. It therefore relates to the kind of abuse adverted to in Johnson versus Gorwood 156 above. It says, in considering whether such an abuse is made out, we have regard to the fact that the parties in the present proceedings are not the same as those in the present proceedings, as indeed was the position in Johnson, they say, the high threshold which accordingly applies. With respect, I say that's where they go wrong. Johnson was different parties but they were privies, was the conclusion. And the high threshold they're talking about is then the decided case, decided point, different parties situation. But nonetheless, they're agreeing this is not a decided point case. They're quite right about. We didn't argue those points out. And then at 167, they say, analyse the situation at the end. They say, having regard to all the circumstances, we consider to commit such a offence would bring the administration of justice into disrepute. So the upshot of that, I say, is that what they have done is ultimately just applied the conventional decided point different party test. They've gone down the second limb, which is administration of justice into disrepute, and simply say that is wrong. That is not the correct legal test. This is, as the tribunal has found, an undecided point situation. They rightly say you need to look at Henderson, but that makes clear it's a principle that doesn't apply to the different party situations. So we say, simply, so I'll show you the two principles, we are outside those two principles. So they have simply applied the wrong legal test. So we say we aren't, and in situations where the test says even in a decided point case it will be entirely exceptional, we can absolutely understand why in an undecided case with different parties it simply doesn't happen at all, not least given the rationale of Henderson, which is being used twice, which doesn't arise here. So we say with respect they erred in principle, which is the answer to my learned friend's reliance on Aldi. This is one of the situations where the court can and should step in. And we are simply, if the proper law had been applied, we should have said it's not a Bairstow situation, it's not a Henderson situation. We have the ruling from Lord Millett most clearly, the rest of the court, the House of Lords in Johnson and Gorwood, we are not in the territory.
What does privy mean?
Privy in that context is, and I'll show you the sections, it's somebody who is so close to being the same person. So somebody, if you control a company, for example, a matter like that, it's not being suggested that...
What role does the Commission perform in relation to consumers when it's conducting an investigation into market abuse? How close is the Commission to the consumers? Is it their privy for this purpose?
Well, I think there are 2 points. Firstly, the case law is dealing with a situation where the wrongdoer is, as in the person who's potentially abusing is the privy in those circumstances. But it's also talking about twice vexing. And it can't simply be in any way suggested that the consumers are being twice vexed by this point, because they had simply no knowledge or involvement in any way in the Commission decision process. So, in respect, I would say it is
not rationale for a doctrine, because consumers haven't been twice vexed, and therefore they can't benefit from the finding, whereas they'd be delighted they haven't been twice vexed. They're being once vexed in the tribunal, but they've had someone, my Lord's point is, they've had someone who's effectively a proxy for the consumers, protecting competition and consumers in the enforcement of the same provisions. Being twice vexed isn't really a rationale for applying or not applying it, is it?
Well, it depends. Obviously, what we're focusing on here is the situation where the point has not been decided. Clearly, if you're going to be on by first ground, that's a separate issue entirely. So then it has been decided. So here we're dealing with a situation where it hasn't been decided. They're not being twice vexed because we haven't gone through the argument twice.
Okay,
and that's the principle.
Okay, that's the vexing.
Yes, or yes, the vexing is, or that you've gone through litigation once, you thought you've won it, and then somebody comes back with a new argument.
Yes.
You have to go through it again. It's not running the same argument again, but
Yes.
in practice you have to go through the same substantial litigation process. So that's the twice vexing, and that's the Henderson principle. So that you say legally.
So in any event, you say this is, and you say it's not a Bairstow type case because there is no finding in the earlier proceedings.
Yes, and for these purposes, the court agrees with, the tribunal agrees with me. This is not a situation in which there has been a ruling. That's at 166. This is not a case where MasterCard is seeking to raise again a matter expressly addressed in the decision. So they agree with me. It's not a point decided there, which is obviously a point I preonate anyway. So we say it's simply we're not in the territory of either of the sets of authorities. So that shorter point. I should also address 170, where they talk about abuse of process as a broad and flexible doctrine. I've showed you what was being talked about there is the Johnson and Gorwood. Once you're within the doctrine of Henderson, you don't then necessarily treat every single argument you could have run earlier. The point being is we are outside the doctrine entirely. So we do say that you know, you can't get sort of round the clear guidance of the House of Lords.
So you say if you win on the first point, i.e. The section 58 point. Section 58.
Well, that's the section you're probably thinking about, but I'm not. Yes, I mean,
You know, i.e. you win on the point that actually you're not bound, statutorily bound by the Commission's decision in a way that prevents you from
yes.
running the alternative. Then you say you definitely don't fail on the abuse process.
That's entirely correct.
No principle of law at all that could ever apply to make this an abuse. So let's assume, for the sake of argument, you lose on, or you win on ground one, but you could have run the point but didn't. There's nothing then in principle at all which could ever make that abuse.
That is one of the most dangerous propositions a judge can ever put to speak, because it requires me to have in mind every conceivable circumstance that ever arise and answer you in a firm.
There's no general principle of abuse which is more free-floating.
That's not in general what the authorities have established, you know, structured, sensible ways of looking at this. Yes, categories are not closed, but the specific point out is addressed in the House of Lords, in Johnson, that you can't move Henderson to a point beyond that. So I do say, you know, there is a structure for these kind of things,
yep.
And you know, in respect, the principles are what they are. They were wrongly applied. And then 170 is a sort of reference to a broad and flexible doctrine, but with respect, that's just, you know, that's not consistent with what the authorities actually say in this regard. There's also no recognition of the fact that this has gone beyond anything that has gone before. So we say with respect they got the law wrong. The second point I would address in relation to this is paragraph 167, which is whether it would be right, whether it would be bring the administration of justice in disrepute. I say that's not the relevant legal test. If you're against me, you think that was the right relevant legal test, I'd say that's wrong and simply not a conclusion that was open to them. I mean, stepping back, the Commission had said visa was exempt at lower MIFs for 5 years. If we manage to show that's right, how could it possibly bring the administration of justice in disrepute for damages to be assessed on that kind of basis? Or similarly, the rates that we were then agreed to for MasterCard in 2009 by the Commission. There's nothing about that that brings the system into disrepute. Fundamentally, the Commission was considering infringement. This court has to consider what would happen without the infringement, the extent of loss. It's just inherent in that, like cartel damages, that the court has to go beyond the pure point of infringement to look at the rest. So I say
just remind us, at the European level, Visa went to the General Court.
Went to the
appealed the decision. Was it MasterCard?
MasterCard appealed our own decision, yes. Visa was happy with its exemption decision, obviously.
Yes.
Because that was a compromise in reality.
Yes. That's right, of course, that's right. Okay.
Yeah. So those are the 2 points that I take in relation to that. We a little bit more on our skeleton, but those are the if you're not with me on those 2 points, nothing else I say is going to make much difference. I do then need to show the court the Commission decision in its unredacted form, which hopefully should be in front of you. Authority 7. And it's recital 13 in particular that is likely to be of interest to the court here, which is the unredaction does clarify more. To accept that, and the points I was saying this morning, I wouldn't put the way I did in light of what it says, which is, I don't know what it says, so orders MasterCard to withdraw its intra-EA and fallback interchange fees. The order does not prevent MasterCard member banks from adopting an entirely new myth other than the intra-EA fallback interchange fees, the separate interzone fallback interchange fees. With respect, I say that's essentially the fact that it's member banks is a distinction largely without difference. The MIFs had always been set until 2006 by delegates from MasterCard's member banks. The whole basis of the decision was that we were an association of the member banks, including after the IPO, and the whole point about if it's the banks doing it, it's still collective, in the same way that us doing it on behalf of the banks is collective. So that clearly can't be seen as being a sort of, it's not a magic bullet to restriction, as shown by the fact that they're talking about exemption. So they still think it would be a restriction. They just think it, well, they're saying if you could show it's exemptable, it will be. So that is a point that is an important clarification, brought to attention for that reason.
Sorry, can I just, again, as coming on, this is a bit of an outsider, but compared to everybody else in the room, I think. When it says MasterCard's member banks, just looked at the definition of MasterCard. I mean, MasterCard is our corporate entities. So what does it mean, member banks?
Well, I mean, that comes back to some extent the definition of association of undertaking. Until 2006, MasterCard was a members' organisation owned by the banks. It was a limited company, but it was owned by the banks. So in competition law terms, it was an association of undertakings, so an association of those banks. And they took those decisions through representatives of the banks making decisions until 2006.
The banks, the member banks, does that include all the acquiring banks and all the merchant banks, all the so in other words, if you the issuer banks and the acquirers, I think.
Acquiring and issuing banks.
Acquiring and issuing banks.
Includes, yes, both, yes. So it's always included both kinds of banks. So all the banks who are members of the scheme, licensees of the scheme is the language we would use now.
Yeah.
But the essence of the Commission's decision was that it was the banks taking the decision collectively through MasterCard until 2006 clearly, and then thereafter, even though it was delegated to a member of MasterCard's management, it was still the banks deciding to allow that member to make a decision on their behalf. So it's still going to be a collective decision.
So it doesn't, when it says it doesn't prevent MasterCard's member banks from adopting a new MIF, does that mean individually or sort of in some other form, or?
It's a MIF, and that's the thing. A MIF is multilateral. So it's not talking about bilateral. It's talking about the banks collectively establishing a multilateral MIF that will apply generally.
So they could do that. Okay.
And they do that in practical terms through MasterCard, and that is, of course, what happened in 2009. Is it was done through MasterCard the way it always happened.
Slightly odd because the parentheses say the banks can adopt a new MIF, but then other than the intra-EEA fallback interchange fees and SEPA intra-Eurozone fallback fees, which are those the subject of this decision, which are prohibitive ones. When you look at the definition of intra-EEA fallback, you may say it's ambiguous, but it does seem to be, it's just fees generally. It's not fees at a particular level, it's all fees.
Well,
so
I come back to how much the weight I place upon other than the interchange fees, which is,
okay.
Yeah, I mean, and it must, to some extent, it can't be saying you can set a MIF other than one that's a fallback cross-border interchange fee, because what else could it be? Well, it's got to be talking about the levels.
The banks can come back with a new scheme, but the one that we've just prohibited can't come back.
Except the new scheme is going to be a multilateral interchange fee, i.e. a collective interchange fee agreed by the banks for cross-border transactions.
The Commission can't rule out in law somebody coming back with something which they prohibited by effect. If, as they say, it clearly fulfills the exemption for it. So as a matter of principle, they can't preclude that. Are they saying any more than, with the avoidance of doubt, this is just this prohibition on coming back with something new applies to the present MasterCard arrangements, but if the banks come back with something else, we'll have to have a look at it.
Except, as a practical matter of reality, they're talking about coming back with a new MIF. They're assuming it's going to be restrictive because they're talking about 81.3.
Yes.
So, you know, they're just saying...
You see, that might explain the visa position. They haven't said every single MIF under the sun is always, always, always bad. They're saying the MasterCard one is.
Yeah. We've
allowed Visa to, you know, and there may be others that we will just look at on the facts, but the same one can't come back.
To that extent, we're not disagreeing. I just define that as being the actual EEA MIFs. And to some extent, if the counterfactual for me is that that MasterCard could have done this lawfully by allowing the banks to take the decision directly at different levels, I'd be perfectly happy with that as an alternative counterfactual for damages.
It is unfortunate that the argument we were addressed on this morning in relation to recital 13 had not disclosed that what it actually says is MasterCard's member banks are not prevented from adopting an entirely new MIF because everywhere else it just talks about MasterCard. So it suggests that they had in mind something that wasn't just MasterCard, as it were, reducing the level of its existing MIF. What they had in mind was a completely different structure. The member banks of MasterCard are entitled to come back with something different.
Except,
there it is.
My lord, I say factually, what the Commission found was that MasterCard member banks had taken the decision themselves through their delegates until 2006.
Yeah.
And thereafter, they'd allowed MasterCard's, a member of MasterCard's management to do it on their behalf. So, the essence of the Commission decision is it always was the banks doing it. So that's the reason I say it's a distinction with no real difference. If it's a distinction which means my counterfactual needs to be the banks doing it themselves, I'm content with that. I'd say it still gets the same outcome, is can I argue for an alternative lawful MIF? What it's set by is, it's never been a point of significance.
Okay.
Please, Your Lordships, the Commission decision, which was adopted in December 2007, followed a very lengthy investigation which commenced in 1992. And there were repeated meetings between the Commission and MasterCard, various rounds of submissions, an expert report, a statement of objections, a supplementary statement of objections, and a hearing. And throughout that investigation, MasterCard adopted a particular stance. It sought to argue that having a multilateral interchange fee was lawful as a matter of principle. MasterCard deliberately did not seek to do what Visa had done. It deliberately did not seek to justify any particular level of MIF by reference to empirical evidence. And it chose not to put any different level of MIF to the Commission. And its strategy failed because the Commission found in the decision that MasterCard's MIF infringed Article 101, and it did so, and this is the key point, on the basis that MasterCard's MIF in effect set a minimum price. That was the vice, that was the infringement. A minimum price which merchants must pay to their acquiring bank for accepting payment in the EEA. And what MasterCard's trying to do in this appeal is have another bite at the cherry, and the tribunal was quite right to say that it's precluded from doing that. My lords, let's pick up first the tribunal judgment again, please. So if we go to CB6 and page 172. And you can see at paragraphs 103 to 104 the relevant parts of MasterCard's pleading. And you can see that paragraph 15 of its amended defence, MasterCard will seek permission to call expert evidence in relation to exemption and expects expert evidence to show that alternative EEA MIFs were above or close to the EEA MIFs actually set. So MasterCard's position, now Mr. Cook says, because obviously it's forensically more attractive for him to say this, Mr. Cook says, oh well, we could have come back with something materially lower. But actually, his argument is that only the very specific level of MIF was precluded by the decision. And that's absolutely wrong. It completely flies against the face of the various recitals and the operative part of the decision. Now, I think it's helpful to look by comparison at the Visa decision, which you'll have in the supplementary bundle behind tab 1.
Yeah.
And if you go, please, to page 6, you can see between paragraphs 30 and 33 a summary of the procedure. And you can see that the visa case similarly was reopened in 1992. And essentially what happened was that the Commission indicated that it did not consider that Visa's MIF fulfilled the conditions for an exemption under Article 81.3. That was part of the procedure. And you can see at recital 31 that in 2001, Visa contacted the Commission to discuss possible changes to its MIF. And a concrete proposal was approved by Visa and put forward to the Commission. And then you see that further contacts, this is recital 33, led between the Commission and Visa led to one further specific modification, leading to the final version of the proposed modified MIF as described in the following section of the decision. So what Visa did was it played it very differently. The Commission said, on a provisional basis, we don't think your MIF is lawful. So Visa engaged with the Commission to establish a level of MIF which was exempt on the evidence, which the Commission would be happy with. And if you look at recital 36, 36 says this: one other card payment system, and we say that was MasterCard, we don't know, but MasterCard has never disputed that. One other card payment system commented that it failed to understand how in law a reduction in the level of a price could have any relevance for the granting of an exemption. It had the impression that the Commission was acting as a price regulator in this regard. And that is, in a nutshell, what MasterCard's position was. Its position was, this MIF has to be, our MIF is lawful as a matter of principle. It doesn't matter what the level of it is. And as I say, that failed, that strategy, because what the Commission found in its decision was that the MIF in setting a minimum price was unlawful, and MasterCard have failed to adduce any evidence to exempt any MIF setting a minimum price. That is the finding in the decision. Now, a framing point, my learned friend accepted in response to a point put to him by my Lord Justice Green, that in fact this is all about, this strand of the appeal is all about the construction of the decision. And he was right to accept that, and the reason he was right to accept that is this, that although the Commission decision is formally binding on the question of liability, and so what was put to my learned friend was, is it different when it comes to causation and loss? It's common ground that when one is looking at loss in tort, one is asking what would have been the case but for the infringement. So that's the counterfactual, but for the infringement. And so one has to strip out the infringement from the counterfactual. And we both agree that that requires you to determine as a matter of construction what the infringement is in the decision. So that's why it doesn't help him. If he loses on the point of construction, he's essentially lost this debate. So it doesn't help him to say, oh, well, yes, Mr. Merricks is right on construction, but somehow the position is different for causation and loss. And to be fair to my learned friend, he very properly accepted that. So on the decision itself, and we have traversed most of the, I think it's clear from the exchanges with my learned friend that the court understands our argument, and so please do hurry me along if I'm taking it too slowly. And I'm afraid that I have cut this short. I'm afraid I'm going to have to do it by reference to the redacted version, just because I didn't get this version until
Sure.
the court came in, and that I'll struggle with references.
Well, we can keep it open, and if there's some
Of course.
redacted part, we can do a cross
That
check.
would be extremely helpful, thank you.
Just give us the recital numbers, will be fine.
That would be very helpful, thank you. So I'm going to go back please to the operative part, and so that's my page number is, so I'm behind tab 45 and it's page 1820. And Article 1, we say, so Article 1 establishes that MasterCard has infringed Article 81 of the treaty. So an infringement obviously encompasses both falling within 1011 and not being exempt under 1013 by in effect setting a minimum price merchants must pay to their acquiring bank for accepting payment cards. So the finding of infringement is in those broad terms. Now, my learned friend says, yes, but that's by means of the MIF. And of course it's correct that the MIF, which encompassed all of the rules, of course, was put before the Commission. But one has to look at what's the scope of the finding of infringement. On what basis was the infringement made? And it's the setting by MasterCard of a minimum price. Now, then you go to Article 2, and as the courts observed, that required MasterCard to bring an end to the infringement. And we then see in Articles 3, 4, and 5 what steps MasterCard needs to take in order to do that. And we see, I think it's probably easier to look at the non-redacted version of Article 3, that MasterCard has to repeal not only the actual fees, but also all of the rules, so the whole of the MIF system and architecture. And then those changes had to be communicated, we see that from Articles 4 and 5, to the relevant financial institutions. And we see an explanation of this, if we go back please to recital 759, page 1816.
Article 3 necessarily covers every decision taken at every level. So, by definition, every level set in accordance with the MasterCard system has to be repealed to comply with the infringement. It doesn't matter whether it's 1%, 3%, 5%, 7%, 0.1, 9.9.
All decisions shall repeal all decisions taken by the board.
So it covers every figure, every quantum.
Yes, the whole thing has to go. So it's not just the actual fees, it's the whole structure. And that's because what was found to be unlawful was the setting of a minimum fee.
Well, I mean, if you think about it, so the decision to set the MIF at 0.5 or whatever it was, what the effect of Article 3 is that decision is abrogated. So there is now no MIF.
There is no MIF, but it's more than that.
It isn't that there's a reduced MIF you can fall back on. There's no MIF at all.
And it's all of the rules which entitle, which all of the rules which go to MasterCard setting the MIF. It's the whole framework. And the reason why it's the whole framework, the whole architecture of the MIF, is because it's the setting of a minimum price, which is the infringement that's been found. So everything has to go. So Article 1 doesn't say, for example, there's an infringement because it sets a minimum price and the level of MasterCard's actual MIF is not justified on the evidence. It's a much broader finding of infringement, and that's really the key point. That's why we're right with respect on the question of construction of the decision. And if you go back to the recitals that explain the remedy, so 1816, recital 759, MasterCard must desist from determining in effect a minimum price merchants must pay for accepting payment cards by way of setting intra-EA MIF, fallback interchange fees. So it's a general finding. They must desist from setting a minimum price altogether. Not MIFs at this particular level, any minimum price. That's really the crux of it. And then if we look at 761...
That's why on one view it covers MasterCard's submission, because any MIF covers everything from 0.1 to 10. So any new MIF which is put forward now is within the scope of this.
Yes. So I'll come to recital 13, but all the Commission is saying in recital 13 is if you come back to us with robust empirical evidence, we don't exclude that you can adopt some different system. That's all they're saying. And of course, my lord, you were completely right to say this is an effects case, it's not an object case, so that can never be excluded. And of course, we see from what the Commission did in Visa and what it subsequently did in relation to MasterCard, that was on the cards. So we're not saying, well, that was never on the cards. We're not seeking to say that this decision says, on no hypothesis can an interchange fee ever be lawful? Of course, that's not our case. We don't need to show that.
You're just simply historically, on the basis of the time period covered by decision, they found that any MIF was unlawful.
Exactly, not just the MIF at the particular level. And if you go back to, think about paragraph 15 of MasterCard's pleading, they say, well, it's open to us to say that even something higher doesn't come within the binding scope of the decision. And then imagine asking the legal team in the commission who was drafting this decision to say, well, do you think that's right? Do you think Article 1 actually means that you think that even a higher MIF than the actual specific level that MasterCard set might be okay? Of course, the answer is just blindingly obvious with respect. Of course it isn't okay. And that's what MasterCard's case amounts to.
Might be called barefaced cheek, frankly. To say, well, a higher MIF would have been.
My lord, and that's why Mr. Cook, in argument before the tribunal and before your lordship, says, well, we could have come back with something materially lower. But his case, let's make no bones about it, is that only the precise level of MIF was precluded. And that just is wrong. Then if we look at 761, you see the point about requiring to modify the whole of the rules. And then 765, to remedy the competitive harm in the market, it's important that acquiring banks pass on the cost reductions resulting from the absence of fees, not from the difference between the fee and a lawful level. And 767, the requirement on MasterCard to cease and desist from setting intra-EEA fallback interchange fees, not the ones, not the specific ones, but fees, it is sufficiently determined, necessary and proportionate to remove the competitive harm. That's what needs to be done to remove the competitive harm. So, my lords, you've got the gist of my point. Can I just show you a few other recitals in the decision? And I've cut this down because we have gone through quite a few already.
The points you just made are also encapsulated at the end of 769, aren't they? End of the last sentence, 769.
My lord, exactly so. It's the absence of the interchange fees, and that's not. It's not it's a substantive point because so the counterfactual is no interchange fees, and that's the position that needs to be restored in order to remove the competitive harm. So that shows you what it was that the Commission thought was the infringement. And to say, well, what my learned friend, what MasterCard are essentially asking, inviting the court to do, is to say, well, the Commission obviously thought that the counterfactual was no interchange fee, and that moreover, that infringement needed to be remedied to restore, to make good the competitive harm. But in this case, we can have another bite at the cherry, because actually, on analysis, this decision is just looking at the very specific level that was before the Commission.
I mean, am I right? I mean, I put it to Mr. Cook. Is it that if all that had been objectionable was the level, that could have been addressed by the revocation of some of the decisions, the resolutions of the various individuals that are identified, but you wouldn't need to revoke the rules or modify or vary the rules, and it's the modification or variation of the rules that seems to be critical, because that's what led to MasterCard being given 6 months to do it.
My lord, I think that's correct. So if it were just the level, I think the operative part would have read very differently, and the remedy would have been different, because the finding of infringement, apart from anything else, would have said, as I say, something like it's unlawful insofar as the level hasn't been justified, or something like that, and it just doesn't say that. And instead,
and it would have been to amend the rules so as to reduce the level of the MIF to that acceptable level.
my lord, yes, and Article 13. So my learned friend says, oh well, we rely on Recital 13, but Recital 13 just can't bear the weight that he places on it, because all Recital 13 does is a prospective provision, and if we turn that up again, and I know you've got it, I don't have it to hand in there, so in 17 in my copy, but you should probably look at it in your unredacted form. But this says that the order doesn't prevent the adoption of an entirely new MIF other than the intra-EA fallback fees that can clearly be proven to fulfil the conditions of Article 81.3 based on solid empirical evidence. And so it comes back to the point put by my Lord Justice Green, it's an effects case. We know from Visa, which went very differently, that the Commission isn't saying you can never, ever, ever have a MIF, but what they're saying is you, MasterCard, have failed to justify any MIF on the basis of the evidence you've put forward.
Just coming back to the point my Lord made, if the advice had been particular levels of MIF, the decision of the association of undertaking would have been classified quite differently. It would have been decisions of individuals, particular dates, setting particular rates for the default MIF, because that's the only thing that would then have been the restriction of competition. It wouldn't have been the system. It couldn't have been the system. It would have been the specific implementation of the system which was not exempted.
My Lord, yes, that's what you would imagine to be the case, and the whole process would have evolved differently. It would have. I've shown you the reason I showed you Visa.
You focused on facts, quantum, and
Yes.
you've been looking at the counterfactual, and you've been putting forward alternatives to say that that it's set at X%, but if it were lower at Y%, we wouldn't get the positive benefits by way of exemption and so on.
My Lord, exactly. And what the tribunal found is that MasterCard deliberately didn't go down that road. So it didn't put forward empirical evidence. It argued it at the basis of on the basis of theory, at the level of theory. And so that's why you don't have that analysis of, well, if it had been half a percentage point lower, would it have been lawful or not? Because that was the road that MasterCard deliberately decided not to go down, because it thought it would be advantageous, but its roll of the dice failed. Now, if we go back to the decision looking at exemption, and we've looked at some of these points already, so I'll take it quite quickly, but can we go please to, if we take it up at 1793, so recital 676.
Yeah.
And this is under the heading MasterCard's arguments. And you can see actually from 673 down to 678 that the arguments are all at the level of principle about having multilateral interchange fees in general, rather than, as I say, empirical evidence designed to justify the level. So you can see at 673 the efficiencies that it claims represent the technical and economic progress of payment card systems. That's the level at which MasterCard was arguing the case. And then
The identification of the quotes decisive question in 679. It's whether the MasterCard MIF, which is as defined, the rules and every implementation thereof. But that's, from the Commission's perspective, the decisive question.
exactly. And if we look at, and 678 in fact, so MasterCard argues that the Commission was wrong to request MasterCard to establish under 81.3 that the interchange fee set at a certain level was indispensable, because such requirement amounted to an attempt to regulate the level of MasterCard's interchange fee. We see that mirrors recital 36 in the Visa decision, which must refer to MasterCard. So MasterCard's whole stance was, we're not going to justify the level because we think we should be able to set any level, and the Commission held that was wrong. That was the argument it rejected. And then if you look at what the Commission says about that, at 690, if we go on a few pages to 1799, whether a MIF should be paid by acquirers to issuers or vice versa, and whether it should be set at a certain amount or at zero, cannot be determined in a general matter by economic theory alone. A claim that an interchange fee mechanism creates efficiencies within the meaning of Article 81.3 must be founded on a detailed, robust and compelling analysis that relies in its assumptions and deductions on empirical data and facts. apart from MasterCard's general assertion that balancing of the demand of cardholders and merchants leads to a better performance of the MasterCard system is inherent and indispensable to the operation of a four-party payment card system, no such analysis and empirical evidence was provided to the Commission. So what the Commission's saying is that the very principle of having a MIF, like which direction the payment should go, whether it's necessary at all, cannot be justified on the basis of economic theory. You do need to provide empirical data justifying the level, and MasterCard has just failed to do that. And so the obvious response, and the obvious response to that by the Commission is it's rejected its argument, and it's found that MasterCard has failed to justify the existence of a MIF altogether. That explains the operative part and the scope of the operative part. Then if we go to, and then you see at 696, for example, that the Commission's request for empirical evidence for a positive impact of MasterCard's MIF is supported by the relatively good output of card schemes without a MIF. So it's saying, well, we need to see evidence that having a MIF in principle is justified because there are others that operate quite nicely without it. So that's why we need to see the evidence.
I think, and isn't this the background of this, is that MasterCard was arguing that it had to have a MIF. I mean, it was saying, is this right, that it had to be able to set MIFs?
Yes, it had to have complete discretion over setting the level of the MIF. It had to have a MIF, and it had to have discretion over setting the level. And so that's why it didn't. So it took a completely different stance to Visa, which engaged with the Commission on the basis of empirical evidence to say, well, look, this particular level is justified by costs, and here's why. So MasterCard's stance was completely different. It said that this is lawful because we need to have a MIF, and we need to, and here on the basis of economic theory is why it's justified. It's the having a MIF in principle and having complete discretion over the level. That's what it was seeking to persuade the Commission was lawful, and it failed. And we see, if you go to page 1809 and look at recital 731, contrary to MasterCard's perception, the Commission's position is not that only the level of a MIF is a decisive criterion for assessing whether that MIF fulfills the first condition of Article 81(3) of the treaty. Rather, the existence of efficiencies is assessed in relation to the MIF as such. So it really couldn't be clearer from that what the Commission's saying. So, my lords, there are other recitals I could show you, but I think I've made the point. I'm not sure it's going to assist by going through, but there are more in the same vein. And so, drawing the threads together, MasterCard says that the Commission was assessing the MIF it had notified.
Well, the 732 is striking, isn't it? Because in 732 they pick up the point about what you need to establish for satisfying 1013, and it has to be robust, compelling analysis based on empirical data and evidence, and all you had here was a general assertion.
Exactly so, exactly so.
And this point was picked up in the Visa and MasterCard litigation in the Court of Appeal and the Supreme Court.
My lord, that's quite right. That's exactly right, and it's a point I may come back to if time on under abuse as well. But you're right to say that, and so what we see is because that we say on its face, drawing the threads together on its face, and just looking at the decision, the operative parts in these recitals, it's clear what the scope of the finding of infringement is. It's not that the specific level of MasterCard's MIF alone was unlawful. It's setting a minimum price. The whole thing is unlawful because it hasn't justified it. It hasn't adduced evidence to justify it. And that is explicable That's easy to understand why the Commission reached that conclusion when one thinks about how MasterCard ran the case, which was diametrically different to how Visa ran the case. So it essentially eschewed any opportunity to adduce empirical evidence to justify the particular level of MIF. It was arguing it on the basis of the principle of having a MIF, and the Commission said, no, that's not right, because you need to show that even the direction of travel of the payment is justified. It's an existential question, the Commission said, and that's the basis on which the decision made the finding of infringement that it did.
If the court under Section 58 is bound by the fact of a violation, then if during the course of a new trial, new evidence is put forward establishing that another MIF higher than that actually applied should have been exempted, doesn't that mean that there is no restriction of competition at all? Doesn't that negate the finding in the Commission decision?
Well, my lord, we say that negates the binding nature of the finding of the Commission's finding. So the Commission, you start with the analysis is you start with the.
And then you're saying the Commission was wrong, and no damages flow from it.
My lord, that was the framing point that I say is actually common ground between us, in the sense that the way it works, we'd respectfully submit, is that the Commission decision is obviously binding under the legislation on liability. So MasterCard can't come to court saying, oh, actually we've got different evidence, our MIF was actually lawful, your claim doesn't get off the ground. So that's a given. Then the question is whether, as you've seen from MasterCard's pleading, whether it can say as a matter of tort law that the damages are reduced because in the counterfactual, a different level of MIF would have been exemptable.
And the Commission got it therefore wrong.
And the Commission got it wrong. The question is whether, well...
Implicitly.
Well, Mr.
It's pretty close to it.
Mr. Cook
You would say no, of course
doesn't
not.
advance that argument.
No, no.
So Mr. Cook's argument, he's right about this. He accepts that if he's wrong on the construction of the decision,
Oh, yeah.
that's
Yes.
not open to him.
No, yeah.
So he accepts that if the decision finds that if we're right on the construction of the decision, he can't make that argument under causation and loss, because you've got to strip out of the counterfactual the infringement found by the Commission. So that's why that particular argument wouldn't work, and he accepts that. So it all does come down to, as the tribunal found, the proper construction of the decision.
What does the decision mean?
Exactly. So my lords, I can move on to abuse unless you have any questions.
No. Thank you.
Now, just to clear one point out of the way on abuse before I get going, my learned friend relied on his skeleton and orally on paragraph 166 of the judgment below. Can I just turn that up, because I think that he's wrong to think it helps him. So it's tab 6, page 64. And so there the tribunal says, this is not a case where MasterCard seeking...
Which paragraph?
I'm so sorry, 166. And it's the first sentence that Mr. Cook relies on. So this is not a case where MasterCard is seeking to raise again matters expressly addressed in the decision. So Mr. Cook says, oh, well, that's contrary to that's inconsistent with what the tribunal found about the binding nature of the decision. But the reason why the tribunal's expressed itself in that way, if you look at paragraph 151, which is on page 189, is that it's only looking at the abuse argument in the alternative if it is wrong on the construction of the decision. And that's analytically where it arises. So the abuse of process point arises only if we're wrong on construction. We don't need it if we're right on construction. And that was the basis that the tribunal considered it too. We say we're right on both. And could I start by reminding the court of the factual basis, which Mr. Cook rather skirted over, the factual basis on which the tribunal found it would be an abuse of process for MasterCard to advance the case it has that we've seen in its pleading. And then I'll deal with the points of law. So if we look at the judgment, if we start on page 189 of the bundle, and you see the heading abuse of process, and if we go forward please to page 191, paragraph 160. So the MasterCard had repeated meetings with the Commission. I won't turn up the recital, but that's recorded in recital 13 of the decision. And as I've said, the investigation was very long running. And if those particular recitals of the decision set out, summarise the procedure and make clear that MasterCard had every opportunity during the long running investigation to say anything it wanted and put forward any evidence it wanted to the Commission. And then if we go over the page, please, to 162, that's the point that the tribunal makes there, that it did have every opportunity to submit arguments to the Commission that the level of its MIFs met the conditions for exemption. And we know from looking at the Visa decision how that would have been treated by the Commission had it done that, because Visa's initial notified MIFs, the Commission said, well, we don't think these are lawful. And there was then a discussion between Visa and the Commission over over a protracted period of time, which resulted then in MIFs that both were happy with. And of course, this was a period of time where only the Commission had the power to grant exemption. So it was pre-modernisation regulation. And so the Commission, it wasn't in the business at that point in time when it was the sole person that could grant exemptions of saying, oh, well, you've notified this, that particular level is wrong, go away. It did, as we see in Visa, work with the parties to try and work out what sort of alternative conduct could be exempt. And that's the point that the tribunal makes at paragraph 164 of its judgment. And then we see at 165 that MasterCard disavowed doing the same thing, and you see the reference to recital 36, which I've shown you. And then at 166, it's a case where MasterCard is seeking to raise an issue which could have been raised in the proceedings, but which it very deliberately chose not to raise at that time.
I think Mr. Cook's point is simply, yeah, okay, even if we could and should, what's it to you? You haven't been vexed. You're not, you haven't been vexed. We're not vexing you twice.
And my lord, I'm going to come to that on the case law, but the short answer to that point.
We have litigated against you before.
Yes, and the short answer to that point is that Henderson abuse, the rationale for it, I'm going to go briefly to Johnson and Gore Wood. Lord Bingham said it's not just about vexing twice, it's also about finality of litigation. And in a sense, it's a point in my favour that this isn't a vexing twice case, because it is a point, but it is a case about finality of litigation. So in circumstances where
finality in litigation is normally, you say it's desirable there be finality in litigation between two parties. Because I think it's almost invariably Henderson is a case where there have been previous proceedings between the parties or their privies, and somebody could and should have raised in the first set of proceedings, and they just want another go.
My lord, yes.
And that's really, as I understand it, the nub of Mr. Cook's argument in this respect. It's even if could and should, it's just, it's not really relevant to you.
My lord, my answer to that is also that those cases, so most of the cases on Henderson and abuse of process are considering private litigation between private parties. So the only case, this is a very particular context, and the particular context is one where the Commission is essentially acting as the public enforcer of the competition rules, essentially on behalf of the public, on behalf of consumers. So consumers can't go around generally, certainly not before there were collective actions, can't go around enforcing the competition rules very easily. So the role of the competition regulator is to enforce the rules on behalf of consumers. The competition rules are about protecting consumers. That's what they're there for. And moreover, it's a context where Parliament has determined that the decision of the regulator should be binding in proceedings. And so what one has here is a situation very close to the situation in Volvo, which is the only other case where abuse of process has been considered in this particular context of follow-on claims. Now, there is a point of distinction between this case and Volvo, which Mr. Cook praised in aid. So the point of distinction, so that's a very similar case. The reason it was similar is because again, it was the parties were not. It was a different parties' case necessarily. So the starting point is necessarily where one has a regime where you have public enforcement and then damages claims. The parties are always going to be different. But in Volvo, the Court of Appeal held, upholding the tribunal, that it would be abusive for the defendants to seek to adduce better evidence to show that some of the factual findings made by the Commission were wrong. Now, the point of distinction you can readily apprehend is that those were findings made by the Commission. Now, they weren't binding findings, but that point the Court of Appeal didn't think was very material, so it treated the case as though they were findings for the purposes of the abuse case law. But it's actually not very different to say, that the abuse identified by the tribunal and by the Court of Appeal in that case, which is that it would bring the administration of justice into disrepute if a defendant who had been found to have infringed by the regulator, competition law, could then, before a court, when faced with claims for compensation by consumers who have suffered harm as a result of that infringement, could say, well, we've got some better evidence here, the Commission was wrong. The Court of Appeal found that that would be abusive. And the difference in substance between allowing that to happen and allowing this to happen, where MasterCard deliberately chose not to raise the arguments, is very slender. In effect, it would be allowing MasterCard to underwrite their tactical decision. So what MasterCard did was it rolled the dice, it tried, as Mr. Cook said, to get something better than Visa had got. And it knew, as the tribunal found, that it was at risk of damages action. So that wasn't something that could have taken it by surprise. And so if it were right that a very rigid approach to the categories of dispute, of abuse, could allow MasterCard to have another bite at the cherry, that would effectively be saying, well, you, MasterCard, can underwrite your tactical decision. You could roll the dice, try to get a better result, and if that didn't work, you could come back before the National Court and argue it all again. And we say that that's very close to Volvo, and a distinction should not be drawn because the vice is the same. That's our key argument. So, my lords, can I just deal with the Johnson and Gore-Wood point?
Yeah.
In fact, before I do that, can I just show you, I said I was going to show you something in Sainsbury's. And if we could pick up, because the vice is similar, although not identical, but similar to the vice identified by the Supreme Court in Sainsbury's. And if we pick up the second authorities bundle, we have different bundles, sorry, tab 36 of the authorities, page 1299. So MasterCard had argued before Mr. Justice Popplewell that its MIFs should be treated as exempt under Article 1013. That was mainly a standalone claim. And we can see from paragraph 229 of the Supreme Court's judgment that Mr. Justice Popplewell had found that they were exempt. And then we see at paragraph 230, and my Lord the Chancellor will recall that the Court of Appeal held that the judge's reasoning was flawed. Then over the page at paragraph 233, despite finding that the approach of the judge was flawed, the Court of Appeal nonetheless remitted the question of exemption back to the tribunal. And if you look at 235 at the top of page 345, you see AAM's argument. So AAM says that having rightly decided that the trial judge should have dismissed MasterCard's 1013 defence and given judgment for AAM on its claim under Article 1011, wasn't open to the Court of Appeal to order that the 1013 issue should be remitted for reconsideration. This offends against the principle of finality in litigation. And then we see at 237 what the Supreme Court held. So we accept the submission of Mr. Turner QC for AAM. The Court of Appeal has erred in principle by allowing MasterCard to reopen the Article 1013 issue, on which, as the Court of Appeal held, it had lost after a full and fair trial of the issue. This offends against the strong principle of public policy and justice that there should be finality in litigation. The court was wrong to characterise victory for AAM as an unjustified windfall or the product of a procedural mishap or accident. So it's different because it's litigation in the courts rather than the commission and then the court. But we say materially it's analogous because the 1013 issue has been decided by the commission, and this is by analogy to the passage there, MasterCard seeking to have another bite at the cherry, which offends the principle of finality in litigation.
Yeah, but again, this concept of finality in litigation is normally finality in litigation between the same people.
It
I
is.
mean, that's the problem. It's not just we don't like points being taken in more than one proceeding in the court. It's that we don't like the same point being taken between the same parties.
My lord, yes, and it's normally that a party shouldn't be vexed, so the point shouldn't be taken against the same party. But here, of course, it's the converse.
Or there shouldn't be two sets of proceedings against the same party when if the claimant, for example, had put all his claims into the first set of proceedings, there would only be one.
Yes, so that's a situation in which that can arise. And of course, one of the rationales, so the rationale, maybe it's better to turn to Johnson and Gore Wood now, and I can make the submission by reference to that judgment. I think that might be easier rather than in the abstract. So that's behind, I think it was tab 18. So my learned friend's submission, as you'll recall, is that this is a different party's case and the point in issue hasn't been previously determined. So we're in a third category, which he says is precluded by Lord Millett's speech. And we make, I'm not sure if it's 2 or 3 points, but anyway, a couple of points at least in response. So if we go to Lord Millett's speech, so page 194,
I don't think anybody else agreed with Millett. Everybody agreed with Lord Bingham, didn't they?
my lord, that was going to be my first point. So we can see that what Lord Millett is saying is that it's all about Henderson, and Henderson is all about double vexation, which is really the point that my Lord Justice Snowden is putting to me. So that's what he says. But nobody agreed with Lord Millett. So the speech that you really have to look at is Lord Bingham's speech.
I think I've analysed these speeches, maybe in Komoka and the Security Service, but I know this point as to whether what Lord Millett had said and whether what he said was something that nobody else agreed with. I know I've dealt with in a judgment, but I can't for the life of me think.
It may be Komoka.
I've done several cases about abuse of process over the years, and this is.
Yes.
I don't want to set a hair running, but you might want to look at Komoka and the Security Service in a completely different context.
My lord, we will have a look at that.
And if there's anything in there that helps, you can both have liberty to put in short written submissions or something.
My lord, thank you. I think that, and we're grateful for that.
I may be barking up completely the wrong tree, but I know I've looked at this issue. Yeah, anyway, Lord Bingham, you were going to show us.
My Lord, yes, so Lord Bingham, so nobody agreed with Lord Millett, so Lord Bingham's speech is the speech that matters for these purposes. And if you go to page 165 of the bundle,
Yeah. Page 31, yeah.
so Lord Bingham says that the underlying public interest is that there should be finality in litigation and that a party should not be twice vexed. So it's 2 points. And we say that it's relevant that he's referring to finality in litigation.
Yeah.
And then he says at letter D, you mustn't adopt too dogmatic an approach. It should be a broad merits-based judgment, which
Wait a minute,
takes...
just before we get to D, the other point that's repeatedly relied upon when you're looking at this case is just below C. There will rarely be a finding of abuse unless the later proceeding involves what the court regards as unjust harassment of a party. So, I mean, reading them together, it's also possible, I think it's often said that the first sentence that you referred to between A and B is really not two separate points, but really
1 point.
one point, two sides of the same coin. Finality in litigation don't vex somebody twice. You know, in other words, it's not 2 points, it's 1 point. I think that's the way it's certainly often put.
Well, my lord, I see that. But may I just step back and put the point in this way?
Put it this way, simply because suppose there are 10 people who suffer a wrong.
Yes.
It's no objection to claimants 2 to 10 bringing proceedings that claimant 1 brought the proceedings first and litigated himself
No.
and failed. That can't be a justification for the defendant in the second set of proceedings saying, well, 2 to 9 or 2 to 10 can't bring these same proceedings because I'm being vexed twice. Yeah, but the point is you're not being vexed twice by the same people unless you get into the other type of abuse category.
My lord,
I
yes.
think that's what's usually argued.
Yeah.
My lord, yes. And so ultimately, just standing back from this, the facts of this case are different materially to cases involving private litigation like this, where you're worried about the same person being vexed by the same point. So it's different because you have a regulator acting on behalf of the public, and we are in the inverse situation here in terms of it's MasterCard that's present in both sets of proceedings. So it's the converse situation. And we're in a situation where you've got a follow-on, a statutory scheme which requires the finding in the first judgment to be binding. And the question is whether, the question really is whether, given that the categories of abuse are not closed, and we see that in lots of cases, including Hunter, given that it's a broad merits-based assessment, are we right to say that the court should take, this is in a sense a novel case, I'm not shying away from that, neither I haven't been able to find an authority that is on all fours, but I rely on the fact that it's a broad merits-based approach and that actually when you look at the substance and the vice, it's not very different to the vice in Volvo. It's the second bite of the cherry point that I've made already. And the question is whether that's wrong on the basis that effectively we say you should be reading Johnson and Gore-Wood as though it were a statute, which if that were right, so if you're, so is it right that the proper, as it were, interpretation of Lord Bingham's speech would be to preclude this sort of case being labelled an abuse, and we say plainly not. He just wasn't addressing the kind of situation we have here, and that's what it really boils down to. So it's distinguishable, it's not binding, it's not, if it were read as a statute, that would be cutting across the dicta in Hunter saying that the categories of abuse are not closed. So that's really what the point comes down to.
From the perspective of being vexed twice as a vice to avoid, I might have said nobody is. MasterCard lost first time round, but they didn't run this argument. They now want to run the argument to have a second bite of the cherry. You've never been in the litigation, they've never been in this litigation, but they could have run it second time. So nobody's being vexed twice. So the vice, which is sought to be prevented, doesn't arise.
It's so It's a different, this is not a vexed twice case. This is a case where we say it would be, that the tribunal was right to say it would bring the administration of justice into disrepute, because it would,
That's the essence. Is there a standalone which really, like Hunter, categories not closed, not vexation twice or of anybody? Does this bring the administration of justice into disrepute?
that's exactly it, and that's what the tribunal found. So if you look at if you go back to the tribunal's judgment at paragraph 170, as the authorities have referred to above emphasise, abuse of process is a broad and flexible doctrine. It's to be applied with caution, but the wording of prior judgments are not to be applied like a statute. In our view, to allow MasterCard to advance the case it wishes on alternative, potentially exemptable levels of MIF would constitute an abuse for the reasons that the tribunal set out that I've reminded the court of. So we're not bound by what's said in Johnson and Gorwood, because that is looking at specific vexing twice cases. And so really that's the question for your lordships. It is a relatively novel point. I'm not seeking to say that I can't wave an authority at you that's directly on point, but we say that by analogy, it's a tiny incremental step away from
It
Volvo.
has wide implications for all regulatory cases.
Well, my lord, it always
And it may
turns.
swing both ways. It may be in your favour. It may be not so much a little incremental step. You may say it's just a justified important step. Mr. Cook will say it's a monstrous step beyond anything which has ever been established in the case law.
Well, my lord, I think as to that, it always turns on the facts. So abuse always turns on the facts. This is a very clear case, we say, of MasterCard adopting a deliberate strategy. And you saw what it said in the visa. It deliberately decided not to do that. So it took the benefit of the opportunity at that stage of doing a bit better than Visa, and it's seeking to underwrite that by having another bite at the cherry, and we say that that is abusive. That's the point. My lords, unless I can help any further, those are my submissions.
Mr. Cook?
My lord, if I could trouble you for 10 minutes and 30 seconds, which I think is still allowed my lord the Chancellor to escape
No, don't worry, I'm
at 3:30. So
His helicopter is waiting outside.
would that
judicial salaries have improved considerably from what I was aware of then, if that was...
you live in.
Okay. I was just start off with abuse briefly.
Yeah.
My learned friend is at 3:20 on Friday afternoon trying to invite this court to invent a new doctrine of abuse of process, which she didn't ask to be done below. She hasn't previously sought to do.
Well, the categories of abuse are not closed, but I think she accepts that she's pushing at the envelope on this one. She just says that this is a clear case of bringing the administration of justice into disrepute.
Which is what the tribunal in fact held at the end of paragraph 167. I mean, so it's not rocket science. It's not entirely novel at 3:20. I mean, it's been put essentially on the same basis that the tribunal.
Yes, and what I say in relation to that is we do have an established doctrine in this country that basically allows people to litigate points, subject to the principles we have, that people don't have to bring forward all of their issues in one set of proceedings if essentially it's subject to the points about deciding points. So if a point is not decided, you can bring it against somebody different without, and that is the way the law works. There is no Henderson and Henderson abuse case. You have an established principle.
So you say if a defendant is sued by A, he can choose which defences to run. If he's then subsequently sued by B on a similar or the same cause of action arising out of the same accident, let's say, he can, if he chooses to run a new defence that he didn't run against A, but he wants to run against B, perhaps because he's got a new legal team or it just occurs to him to run the defence. There's nothing abusive in that. He's not vexing anybody, he's just actually running a different defence. The question is, I suspect, is there sufficient that connects the Commission on the one hand and the claimants in this case on the other, given the nature of the proceedings, to depart from that sort of private law analysis?
Which is why I do pray in a sort of the basis of Henderson and Henderson, which I agree finality and vexing twice are two sides of the same coin in relation to that. There isn't a sort of, there is no situation like that here that we're vexing twice the same people in any way. So the sort of the public law aspect of this with respect doesn't add anything, because you know that's what you're not doing. You're not making somebody's life difficult twice. So I do say that is just not sufficient to extend it when you've got clear authority basically limiting the doctrines in the way in which they have. So my learned friend prayed in aid Sainsbury's in the Supreme Court. Of course, that was a situation where we'd had a trial with Sainsbury's, which won, but the Court of Appeal said that was wrong, overturned it. So we had a trial on this issue. It had then been determined. So, and we were given incredibly generously a second bite of the cherry. That was said to be too generously by the Supreme Court, but that was a decided. Well, it was, I think, probably motivated by a desire to get a common outcome for all the cases.
Well, I think it was because it was thought that everything should have been in the cat.
Whatever the reason. So that was a decided point.
Not necessarily
Same
that
party.
dissimilar from here. You had a chance, you failed to win first time around, you can't keep litigating it. Wasn't that the Supreme Court's logic?
What's that? Sorry.
It's not dissimilar to the argument here. You had your chance. If you didn't run it first time round, the Court of Appeal said, yes, we can remit it for another go at exemption. The Supreme Court said, well, no, you've lost on 81.1. You can't have another go at 81.1 by trying to rerun exemption. Wasn't that the
No, because there had been a trial on 81.3, 101.3. So there had been.
So the Court of Appeal had remitted 81.3, hadn't they?
Had remitted 101.3,
Yeah.
but had found that we should have lost on it. We actually won on it on 101.3. So 101.3 had been decided.
That's right.
So it's the same point, same parties. So it is about as far away as it's possible to get. I mean, it was borderline issue with Stoppel, apart from the fact that the Court of Appeal kindly said, you should have lost, but we think we'll give you another chance. But you know, we'd had the whole process already with all the evidence on exactly this issue, so it had been fought out. So it's a decided point, near enough, same parties, and it was simply, no, there shouldn't be a second trial on exactly the same issue between the same parties. So, you know, that's realistically as close as one could, as far away as one can get from the text really. So I do say in relation to all of this that the conventional law is an appropriate and sensible structure for all of this. We are very far away from Volvo in a critical respect that English law recognises. Volvo was something where the point had been decided. More importantly, the reason why it was abusive is in order to sort of accept the settlement, the settling parties had agreed to the entirety of that decision. So it was a decided point, and they specifically agreed to get the settlement. So we are, you know, it is a substantial and very important incremental step. We sort of put the words in, and I would respectfully agree with what a dramatic change this would be. It's a dramatic change beyond Volvo, recognising as well all the language we have that the kind of Volvo test is rarely apply extreme circumstances and everything else, and then we're pushing it to a level of undecided points. I respect saying that's just simply inconsistent with principle. Very briefly then on the Commission decision, I know you have my points on this, but the sort of the crux of my learned friend's submission was that the infringement was setting a minimum price. That wasn't the infringement. The infringement was the EA MIFs which had the effect of setting a minimum price. The conduct was the EA MIFs. That had certain consequences, which is why there was an effect upon competition, but you cannot ignore the conduct which was wrongful, and that is the critical bit. It was also suggested an argument that the effect of the requirement to repeal every decision meant every decision on any MIF. Well, it meant every decision we'd actually take on every MIF, on this we take. With respect that, you know, so if we'd had a decision that said the MIF will be 1%, as was often the case, so that decision had to go. That doesn't in any way mean the Commission was saying if there had in fact been a decision at a different level. It's just, again, not dealing with that. It's dealing simply with the actual decisions which were on the actual levels, which I agree were found to be an infringement. It was also suggested that, you know, arguing for a higher MIF would be barefaced cheek. It's barefaced cheek I don't dare to put forward, which I haven't. And perhaps in a slightly different way by my Lord Justice Green, that if we try to argue for a higher MIF, that would contradict and undermine the Commission decision. That might well be right, but we don't try and do it. which is why my target is one that's going to be, I say substantially lower, just to, I'm not sort of saying 1 basis point lower. There's a point at which it's materially the same, and I'm realistic about that, which is why I say it has to be materially
Well, it's fair to
significant.
say you hadn't repeated the point in your oral submissions.
No, I didn't make a point of my written submissions either. So it was a point that we'd expressly accepted before the tribunal in relation to that, because I don't have that level of barefaced cheek. The other point was, I think it was an exchange that was put to me this morning by Lord Justice Snowden, and it was then put again to my learned friend, which is whether the rule itself is an infringement. But the rule actually allowing interchange fees, whether that alone was an infringement. That is actually, and I've gone back and checked, that is a point that's actually been decided. It was decided by the tribunal in a case called Westover, and hand up copies. So that addressed the period after 2008, the 1 year period when we had a zero MIF. What we had during that period was the same rules that provided for there to be EEA MIFs, so we didn't get rid of them. We had a zero MIF, so we made a positive decision to have a zero MIF. There was a question about whether that was an infringement of competition law. Unsurprisingly, they said it wasn't an infringement of competition law. I say unsurprisingly, because that, of course, was the Commission's counterfactual, a zero MIF. So there is actually a prior finding.
Sorry, I'm just struggling with this. Are you saying that you didn't do what the Commission had ordered you to do?
We are saying the modifications that we made didn't extend to removing the rule in a way. So we kept a rule which allowed for EMIS but set it at 0, and the Commission was comfortable with that. And the reason why was because that is not a restriction to have a zero MIF, because the Commission was happy with that. So that decision both records that we did do that and found that it was not a restriction of competition to have a rule allowing for an EMIF, but actually exercising it to have a 0.
My lord, it's rather unsatisfactory. So my learned friend says that he's got copies he can hand up, which no doubt he got over lunch, and this is a point.
I've had them in the last 10
Why was I
minutes.
not told about this? Why is it a point that's being made in reply? I've got no idea what the point's about.
It doesn't sound like a very promising point.
Well, I hope
because
it's not.
If the truth is that the MIFs were set at 0,
Yes.
then...
No, and ultimately, my lord, the decision says you have to construe the decision on its face. So I'm not sure that it assists my learned friend, but it's just that I'm not able to deal with it now at 3:30 after the reply.
But it's, and to some extent, it's making good what I say is anyway, the position that a rule with a 0 MIF is never been suggested to be unlawful.
Well, it is
Contrary,
a
that's the
bit
Commission.
surprising that this point didn't emerge at an earlier stage if there was a decision taken
I mean, there are
to
two.
set a 0 MIF.
I mean, there were two questions in my head. The first is the Commission having said you must within 6 months do X, which basically, as far as I can, certainly on one view of the wording of its decision, is dismantle your entire apparatus for imposing either the two defined fees. And we've had a long debate today on that. If either the Commission subsequently said that isn't what we meant, I'm surprised we've only just been told about it, or if the Commission said nothing but you didn't, and then that came up in some subsequent proceeding, is that what you're actually saying?
Well, firstly, it is something that everyone knows about because it's actually a pleaded sort of acknowledgement of this case that we set a 0 MIF from June 2008. So that is something that is known. It's a point that arises in relation to, I think it's in my learned friend's pleading, that particular point that we set a 0 MIF from June 2008. The question was then, there was a claim against us as to whether that was unlawful conduct, and the ruling was it was not, because rule plus 0 MIF is not an infringement.
Well, just to be clear, did you set a 0 intra-EEA fallback interchange fee, or did you set a 0 entirely new MIF?
The only distinction between it is the fact that it is a 0 number. It's a fallback interchange fee for cross-border transactions, and it was at 0. And that is,
Well, again, but it goes completely to the debate we were having earlier, like it or not, about the meaning of the words in recital 13 and the words in brackets.
it absolutely does, and I acknowledge that. So it's one where I've gone back and checked the position. It's become rather more important in today's hearing than it was previously. But there is a CAT ruling that says maintaining the rule as we did with a 0 MIF, which is known about, the claimants plead that, or recognise it as being the limitation on their claim time period.
So
That was not an infringement.
What instrument are we talking about? We're not talking about a commission decision or a CAT ruling.
So this is a CAT judgment.
So the claim for damages is based upon the commission decision, and that then, for our purposes, we have to construe that decision. The CAT may or may not have construed it differently or applied it differently, but don't we just have to construe the commission decision?
We have to absolutely have to construe the commission decision. I'm
So this
simply
isn't the case with
drawing
the
to your
commission,
attention that maintaining a rule with a 0 MIF, I would say, is not unlawful, which is the point that's been suggested.
You said it's a CAT decision which
and there's the
confirms
CAT decision that confirms.
No
that it
commission
isn't-
decision.
No commission decision.
But it confirmed that it's not a restriction of competition, so there is no
No.
infringement.
What's the answer to the question? Was there a further decision by the commission that your 0 MIF under the same rules did not amount to a failure to comply with what they told you to do?
Not a formal decision.
No.
They obviously knew about it and had no objection to that. So,
Right.
yeah, so there would otherwise have been
With
very
respect to
substantial
this,
penalties.
it's deeply unsatisfactory for this to emerge at the very end of a 3-day hearing. What I'm going to suggest, rather than anybody trying to deal with this on the hoof, that you must produce this decision of Westover, whatever it is. So provide it to Ms. Dimitru. She should have the opportunity to make in written submissions about it that she thinks fit, and I'll give you within, let's say, 14 days, and I'll give you 7 days thereafter to put anything by way of reply. But I would restrain yourself from saying too much, because it does seem to me, as I said a moment ago, it's pretty unsatisfactory. And I'll also, as I indicated earlier, I mean, don't spend a lot of time, because I may have got it completely wrong, but have a quick look at Komoka, and if there's anything in there that might be of relevance, you can put in some written submissions. Is there anything else?
Only one final point was just by Lord Justice Green that if we were arguing for a lower MIF, we'd be saying the Commission got it wrong. In fact, that is not how I would put it. I would be saying the Commission, so if we had a 1% MIF, the Commission said that's not exempt, I'd come forward and say 0.5%. I'm not saying the Commission got it wrong. I'm saying, yes, they were right to reject 1%, 0.5% is fine. So I'm not in any part of
That just
saying
comes back to the
Commission is
implications.
wrong.
If you're right on construction, it will follow, but if you're not, it doesn't.
Okay. Right, well, this, subject to that reservation I've just made, thank you all very much indeed for your helpful submissions. Thank you for finishing on time, just about, and inevitably we'll reserve our judgment. When you get the draft judgment, it will have the embargo on the front of it. Please make sure that that is complied with. And if it is necessary for anybody else to see the draft judgment, you'll have to make a specific application to the court. The draft judgment is for typographical and similar corrections, not to revisit issues. So again, please make sure that doesn't happen. And it doesn't happen very often, just occasionally it does. But thank you again very much indeed, all of you. Have a good bank holiday weekend, although I gather it's going to be raining most of the time, which is a typical English bank holiday, really, isn't it?
Court rise, if able.